Before referring to the reparations system of the Inter-American Court, we will say a few things about the black letter law that the Inter-American Court applies when solving a case. You would think that the court has jurisdiction to adjudicate on cases referred to violations of the American Convention on Human Rights and other treaties that granted jurisdiction, such as the Inter-American Convention Against Forced Disappearances or the Protocol of San Salvador in relation with two socioeconomic rights. However, the court has been very, let's say, inclusive in its adjudication, and it uses other instruments that don't give jurisdiction to the court as a way of interpreting the rights of the convention. You may think that this is a standard way of proceeding, but at times the court goes way beyond the American Convention on Human Rights. In order to do so, the Inter-American Court usually refers to Article 29 of the Convention, which the court interprets to be a norm that refers the court to other conventions, norms, or declarations on the matter of human rights. We consider that this reading of Article 29 is inadequate, but we don't have enough time for dealing with this here. Nevertheless, we can say that applicants to the Inter-American system shouldn't be shy in their petitions, since the system may agree with unconventional requests. Now, we will refer to another theme in which the system is very original: the remedies or reparations it grants. At the beginning of the court's operation, the remedies were considered even more original because back then, the European counterpart of the Inter-American Court would only grant compensations. The Inter-American Court, by contrast, would grant compensations, the amendment of laws, the building of monuments, the teaching of members of the government, etc. There are different kinds of remedies or reparations that the court grants. First, monetary compensations. Second, rehabilitation. Third, satisfaction. And fourth, guarantees of non-repetition. The court generally also grants expenses. Well, it is not necessary to refer to monetary compensation. Everybody knows what they are, except for saying that the court grants compensation for both material and non-material or moral harm. The court excludes, however, punitive compensation. Here, we're going to make a short parenthesis in order to say that the court considers that not only the initial victim is a victim. I will explain this a little bit better. We will call initial victim the person who was directly injured by the state. Let's say a person who was imprisoned without the due process guarantees. The thing is that the court will consider that not only this person is a victim, but also his or her relatives, insofar as they also endured a mental or moral damage to their integrity as a consequence of the suffering of their relative. For instance, the court will consider that the mother of the initial victim is also a victim because she suffered with the suffering of her child or because she had to invest time and money helping the initial victim. Now, going back to the different kinds of reparations. The second kind of reparation are the measures of rehabilitation. They refer to orders that seek to restore the victim to the situation that he or she had before the violation. That means, for instance, that if the person was expelled from his or her position as a judge of the state, he or she should be reappointed. It also includes medical or psychological care to a victim who was injured and needs this kind of care. In the third place, measures of satisfaction. They refer to other ways of giving some moral redress to victims, such as requiring the state to publish part of the judgment in the official gazette, or naming a school or a national park after the victim, or erecting a monument that honors the victim, or asking the state to apologize for its actions. Finally, the court may grant guarantees of non-repetition, which refer to what we could say are legal or public policy measures for preventing the state's violation of other people's human rights. This kind of measures may include the modification or abrogation of statutes, even the amendment of the domestic constitution, as it happened in the case of Olmedo Bustos against Chile. It may also ask the state to give human rights classes to some bodies of the state, such as the military or the judiciary, or it may require the state to make available some medical service to its citizens. As you can see, the court has a very broad system of reparations. It does, however, require some kind of link between the violation and the reparation that the party requests. For instance, the court will probably not grant a request that a school is named after a victim unless the victim was related to that particular school, either because he or she was a student or a teacher there. In addition to the advisory, and now we finished with the theme of reparations, and we want to say that in addition to the advisory and contentious jurisdiction, the Inter-American Court has two related functions. First, the function of monitoring compliance with the court's judgments. This is a mostly administrative function where the court confronts the victim, the Inter-American Commission, and the state's version regarding the fulfillment of the relevant judgment, of the reparations of the relevant judgment. In spite of this being mostly an administrative function, the court has created a great deal of case law because every so often the court has to decide some issues that go beyond the mere administrative work. The second additional function is the granting of provisional measures of protection. This mechanism is similar to the Commission's granting of provisional measures, with the sole difference that the decisions of the court are binding. We will not dwell more on these functions because this would take us far more time than the one that we have for this short class.